On this episode of Race Talk with Lane and Eugene, wrongful convictions expert attorney Jeffrey Deskovic, Esquire, shares his personal experience with wrongful conviction and speaks with us about the need for justice reform in the state of New York and the country. This episode originally aired June 16th, 2021.
Hey, well, welcome. It is time. Welcome back to another Race Talk Revolution with Lane and Eugene. This is where your voice matters. Our topic today is justice reform. And our speaker today is Jeffrey Deskovic, Esquire. Mr. Deskovic is stepping in for Miss Latonya Myers, who couldn't be with us today, but we will have her here at a future date. But before we introduce our speaker, let me just remind you that Race Talk Revolution is a respectful, inclusive platform which is designed to encourage constructive dialogue around these tough issues pertaining to racial and social injustice here in the beautiful country called United States of America. Race Talk Revolution is a safe space for people of all backgrounds to share, to learn, and to grow their anti-racism muscles. In this community, we practice radical inclusive love. Even when we don't understand or agree with what's being shared, we listen with respect, appreciation, and empathy. You see, it is Lane and my commitment that every person be encouraged, heard, and appreciated, because on Race Talk with Lane and Eugene, your voice matters. Lane?
Good afternoon, everyone. So happy to see everybody. Welcome, welcome, welcome. Also want to welcome all of our first timers here today.
I see a
welcome.
Few.
Yes, it's so great to see new faces. This is a love inclusive place and you are welcome here anytime. So make sure you ask your questions and participate. These conversations are for your benefit and for the benefit of all of us. So today, our speaker is Jeffrey Deskovic, Esquire. He is an internationally recognized expert on wrongful convictions and the founder of the Jeffrey Deskovic Foundation for Justice, which has freed 11 wrongfully convicted people and helped pass 3 laws. Jeff is also an advisory board member of the coalition group It Could Happen to You. He sits on the Global Advisory Council of Restorative Justice International and is a co-owner of the Recharge Beyond the Bars re-entry game, which facilitates the formerly incarcerated reconnecting with their families and friends. Jeff's motivation is that he spent 16 years in prison from 17 to age 32 for a murder and rape that he did not commit, prior to being exonerated by DNA evidence. His story is the subject of the documentary short film Conviction, which is available on Amazon Prime. So Mr. Deskovic, welcome to Race Talk with Lane and Eugene. I watched the documentary. It's wonderful. I encourage everyone to watch it, and I'll put the link in the chat as well. If you would, sir, please tell us about your experiences and the work that you're doing around justice reform.
Yeah, so in terms of my experiences, as you mentioned, I did serve 16 years in prison prior to being exonerated by DNA. Presumably we'll get into that a little bit later, but in terms of the justice reform work that I'm doing now, so the foundation is engaged in freeing wrongfully convicted people. We do have 10 cases that are active right now. And we also have the preventative aspect of it. So we are engaged in policy reform work aimed at preventing wrongful conviction from happening in the first place. In terms of the 3 reforms that we were able to pass, we helped pass, in New York, we helped pass videotaping interrogations, recalling that coerced false confessions have occurred in 25% of the DNA-proven wrongful convictions. And one of the reforms aimed at preventing that pertains to videotaping the interrogation. Helped pass identification reform, keeping in mind that misidentifications cause wrongful convictions in 75% of the cases, and also DNA database expansion. So again, as we'll get into later, I was, in short, I was exonerated through the DNA data bank. So not only what did the data bank exonerate me, it simultaneously showed the guilt of the actual perpetrator whose DNA was in the data bank. Hence the rationale for DNA database expansion upon conviction. In terms of current efforts, with the coalition group, it could happen to you, which the foundation is part of that coalition, and I'm an advisory board member of it. We just now passed through the legislature. It's pending Governor Cuomo's signature. The Commission on Prosecutor Conduct, which is an independent oversight board that would be empowered to investigate allegations of prosecutorial misconduct, and that's really important because in the overwhelming majority of all the wrongful conviction cases, prosecutorial misconduct is a factor that runs through all of those. And we are trying to get rid of the exceptions to videotaping interrogation. So when that law was passed, it unfortunately came out watered down. The legislature made exceptions for sex offenses, drug cases, certain type of homicides. So our position is that if the theory of having videotaping interrogations is to prevent wrongful convictions caused by coerced false confessions, then why would we want to have any exceptions to that? In which of those cases, so we're saying that some of those cases, it would be acceptable to have a wrongful conviction caused by coerced false confession. So that's in terms of what we're doing now in New York. A couple of other measures, we previously passed that bill before Governor signed it into law. The District Attorneys Association of New York, they didn't want any oversight, so they filed a lawsuit. They alleged that the law was unconstitutional. The judge rejected their challenge, but found a problem, ironically, and of all things, the appeal process. So due process we built into that law to benefit the prosecutors was what they ended up using to bring down the whole law. So we've repassed it, addressing the judge's concern as to that appeal procedure. And the other thing we were able to pass in New York pertained to discovery reform. So what that means is pertains to information sharing between the defense and the prosecution. Previously, what would happen is that the prosecutor would only be obligated to turning over evidence and witnesses of people that they were going to call either at a pre-trial hearing or at the trial. So beyond that, they would not be obligated to turn any of that over. They would frequently turn that information over on the eve of a hearing or eve of a trial, which would not be enough time for defense lawyers to assimilate the information and help strategize around it, build their theory of the case. Of course, an exception was they're supposed to turn over evidence of innocence as well. But beyond those two categories, they were not obligated to turn over any of that information. But working in coalition, we changed that law. So we took New York from being one of the worst states in terms of discovery to one of the best ones. So now all the evidence has to be turned over automatically at the time of arrest. And then they have 15 days to provide whatever they don't have, and they have another 15 days after that. So beyond a month, they would have to start asking for a court permission. So just wrapping really quickly up this question in terms of other work that we're doing policy-wise, we do have a chapter in Pennsylvania called Pennsylvania Could Happen to You. So the foundation and myself are active in that chapter and in the one in California. So in Pennsylvania, we were able to help pass a bill that would provide automatic expungement of records for people who were exonerated. So what that meant was that previously people who would be proven innocent in court still had a crime on their rap sheet. So that was hurting exonerees when they went for job interviews and in other contexts. So we helped to pass that. Pennsylvania is one of 14 states that does not offer compensation. So that's the main issue we're working on in Pennsylvania. So imagine if you did time wrongfully, and then when you came out, you learned that the state was not obligated to pay you anything. So that's the situation in PA, and we're trying to pass the oversight of prosecutors there. And in California, again, the oversight for the prosecutors, and we think that there's an opportunity to kill the death penalty, which, amongst other things, it definitely risks the execution of innocent people. And we already know that there's racism built into the whole death penalty system, and we'll cover the intersection of that later. So really quickly, those are the issues that we've been involved in primarily, and we've done a lot of support work with RAP, release aging people in prison, with respect to elder parole and fair and timely parole.
Yeah, thank you. Yeah, that's a lot. You said a lot. So let me ask you this, because I know that you started out doing advocacy work even before you became a lawyer. So tell us a little bit about, the advocacy work. What did you see when you were inside that had you, realize that you really needed to give back and start doing some work in this area?
Sure. So I did advocacy work prior to being an attorney, and even prior to having the nonprofit organization. I did that for 5 years. So in terms of what I saw that was disturbing, so I saw people in prison who were over sentenced. There were people that were in prison just for drug possession, and they had more time than people that were there for crimes of violence or even murder. I saw elderly people in prison. I mean, it's a dirty open secret in our society that the medical care in prison is substandard. It's even less equipped to deal with the advanced medical needs of elderly prisoners. I saw many prisoners who would have bachelor's degrees and other college and have completed vocational trades and therapeutic programs which were supposed to address the crime for which they were there. Many of them had excellent disciplinary records. Some were living in honor block. Many were functioning as role models for the new prisoners coming in. And despite that, when they would go to the parole board, they would be turned down for parole based only on the nature of the crime, meaning what the charge was. Now, that's something that would never change, right? So that type of approach in which people go to parole board, get turned down, reappear in front of the parole board in 2 years, get turned down again, and have that cycle continuing in this maddening, never-ending cycle. It demotivated the prisoners. I mean, I had prisoners tell me, why should I bother to change? Why should I take any of these programs? Why should I better myself when they're not going to release me at all anyway? And that type of approach as well, it completely abandons any idea of a belief in rehabilitation. So parole board assessments should be based on whether a prisoner could demonstrate that they've been rehabilitated and that if released, they would live and remain at liberty without breaking the law. So that really disturbed me. Seeing the elderly people in prison disturbed me. Many of them were very sick. So some of them were living so sick they were living on the hospital that was located in the prison. Others were just in a certain cell block that made it a little bit easier for them to walk to the hospital. But some were, many of them were literally pushed around in wheelchairs. They were hunched over, walking with canes. Some had required dialysis. So that really disturbed and saw me. And I saw other prisoners there that they would put in for compassionate release, which means that if the prison medical team, if they determined that a prisoner was terminally ill, they could file the compassionate release to request to be released prior to the sentence being up, so they could die with a little bit of dignity with their friends and family in a free environment. And often they would take so long to make a decision that sometimes people would pass away. The decision would come after that, or they would pass away within a day or two of being released. That's how long it took. So that really disturbed me. It disturbed me, the verbal abuse that a lot of the guards, and non-professional behavior that many of the guards would engage in, and the prison administration really would basically have like a hands-off attitude, and as would the court. So that bothered me, and the amount of prisoner-on-prisoner violence. I mean, they didn't even attempt to prevent and stop violence, and then when they took the college education out of prison. So college education for prisoners is a very serious crime-fighting tool. So nationally, there's a 68% recidivism rate. But for college-educated prisoners, it's much lower. So there's a organization called Hudson Link nonprofit that brings college education for prisoners, trying to fill
New
the
York.
gap.
Now that's in New York State, right?
That would be in New
Hudson
York
Link.
State,
Okay.
right? And they only have a 2% recidivism rate. So my point is extrapolating from that, just when removing the college education from the prison, it was harming the society. It was beyond just harming the prisoners and their family. I mean, that would be enough, but it would harm society at large. I mean, who do you think has a better chance at making a successful reentry into society, to a crime-free life? Somebody who now has some skills, they're equipped for gainful employment, their perspectives are broadened. So I remember seeing a lot of prisoners. They went from talking about war stories from when they were running the streets and engaging in crime and other unseemly things, to talking about what they hope for their future careers would be, which doing like drug counseling or working in nonprofit settings, or working to prevent at-risk youth from ending up in the same place. So I saw the transformative effect, and I benefited from it. I had that much less ground to cover when I was released. So I got the associates and a year towards the bachelor's. And so when I was released, I was able to finish the bachelor's, go to get the master's and the law degree, rather than starting from scratch. So that disturbed me as well. And later on, there really isn't enough reentry services that really are making a difference. I mean, the main problem that formerly incarcerated people have is trying to secure gainful employment and housing. So a lot. I see that as another issue. And
Yeah.
all those
Thank
things
you.
are unacceptable to me, because you're sent to prison as punishment. The punishment is supposed to be the loss of your freedom. It's not supposed to be that you're mistreated while you were there, and hence my having the strong secondary interest in the other justice reform issues.
Yeah, thank you for that. And it is very difficult if you don't have hope of release, and you don't have an outlet for self-betterment, rehabilitation really is a pipe dream. As you said, it's not, and we've known this, that our prison system is not really about rehabilitation. So what about your release? How was the DNA evidence uncovered? I watched the documentary. It seemed that you were quite surprised by it. So tell me a little bit about that, if you would.
Sure. So my wrongful conviction itself was caused by coerced false confession, prosecutorial misconduct, fraud by the medical examiner, terrible public defender. And I lost the trial despite a pre-trial negative DNA test result. I lost 7 appeals, and I also got turned down for parole based on my maintaining my innocence rather than expressing remorse, taking responsibility. And of course, nature of the crime was something else that was cited. So when your appeals are over, the only way back into court is if you can find some previously unknown evidence of innocence that probably would have resulted in a different outcome. So other than that, you're permanently locked out of the courthouse. So I wrote letters for 4 years trying to find an attorney and/or an investigator that would take my case for free, because I didn't have any money to hire anybody. So I did this letter writing campaign for 4 years. And eventually, one of those letters accidentally found its way to an investigator. I was actually writing a book author in care of the publishing company. Someone in the publishing company instead sent it to the investigator. And when she saw the DNA didn't match me, she was convinced of my innocence, because she had never saw a case before where the DNA excluded a defendant and yet a conviction resulted. So she suggested I write the Innocence Project again. She lobbied them from outside their organization. She got other respected legal entities to lobby them. The investigator's name was Claudia Whitman. And then I also got lucky that one of the intake workers, Maggie Taylor, who's now a lawyer, she had to present my case to the attorneys 3 times. I mean, the first couple of times they said no, and finally she got them to take it. And the reason they were saying no is because the methodology they were using to free people would be just get DNA testing, and if the results excluded their client, then present it to court as newly discovered evidence. But that wasn't an option in my case, because the DNA wasn't new. The results were known before. So what ended up making the difference is, with the DNA data bank, we could go from saying that it wasn't me to not only it wasn't me, but it was him. So
Oh
getting
my
their
gosh.
yes, so getting their representation was the first key. Second thing was Janine Pirro, who does commentary on television. She was the Westchester DA at the time, kept becoming DA before my first appeal was decided. So she fought all 7 of the appeals. She blocked me from getting DNA testing several times. So her leaving office was the second key because her successor allowed me to have the further testing. And the third thing is we got lucky that the actual perpetrator's DNA was in the data bank
In the
because
database.
he left free. He killed a second victim who was a school teacher and had 2 children. He killed that second victim 3.5 years later after killing the victim in my case. So on September 22nd, 2006, my conviction was overturned. And then on November 2nd, 2006, all charges against me were dismissed on actual innocence grounds. And the actual perpetrator was arrested and convicted for the crime.
Wow, dude. Wow. Wow.
Mr.
So
Duskovic.
basically,
Oh,
yeah,
I'm sorry.
go ahead.
Go ahead,
No, go
Lane.
ahead. No, go ahead, Eugene.
I have a quick question. So you're speaking about the coercion portion. How often does that happen?
Yeah, 25% of the DNA proven wrongful convictions, coerced false confession caused that conviction in the first place. And I'd like to quickly add that while adults have been coerced into false confessions, particularly vulnerable populations would be people with mental health issues and youth, which I was a youth.
Wow. Yeah.
And in my case, the interrogation, it was not videotaped. There was no audio tape, no signed confession. So when they came to court, the police officers left the threat and false promise out of their story. So all those were things that they would not have been able to get away with had videotaping of interrogations been in play. And ironically, in my case, it was a rape charge, right? So that's one of the exceptions to the law as it is now in New York. So this could still happen now. It's unaddressed by legislation on the books, and hence the need to modify that law.
Did you also say that 70% of false identifications lead to convictions? That's not what you said.
No, I mentioned 75%. So misidentification has been the cause of wrongful convictions in 75% of the DNA proven wrongful conviction. And I want to add that while that's true generally, cross-racial identifications are particularly problematic. So when a person of one race is identifying a person of another race, then that's an even less reliable indicator.
Yeah, that is interesting. Can you say more about that?
Yeah, because I mean, if you're not used to interacting with a member of another race, then I mean, I hate to sound stereotypical, but the people look more similar. So like if I was to be in a situation where I had to identify an Asian, for example, I mean, and that's just simply not a population that I normally interact with, where I live at. So it's harder for me to distinguish, but one Asian from another. So that's what I mean by that.
Yeah, no, this has been proven. And Eugene and I actually talked about that on another segment a long time ago. Remember, Eugene? We actually discussed the inability to distinguish facial characteristics across racial lines. Yeah, very, very good point. So say a little bit about prosecutorial misconduct, because that's obviously a very big deal, in play a lot, hard to do anything about. Can you say something about that, please?
Yes. So prosecutorial misconduct, the most common form of it would be making improper statements in the opening statement or in the closing argument. But other forms of prosecutorial misconduct would involve withholding evidence of innocence. Another aspect of it is that if a witness lies and the prosecutor knows it, they're supposed to correct that witness. But a lot of times they don't correct the witness, and the witness sometimes even lies about the fact that they've been given a benefit from the prosecution. And in many cases, not only do they not correct it, but the prosecutors also affirm to the court that there's no deal in place, even though there actually is. So the problem has been that there hasn't been any effective oversight for prosecutors. So neither the Bar Association nor the Grievance Committee has really done anything about prosecutorial misconduct. So New York is third in wrongful conviction frequency, and none of those exonerations that happened there was a prosecutor ever disciplined. So there's no independent oversight. You cannot sue them. They have what's called prosecutorial immunity. So any misconduct they do, if it happens after an arrest, then you would not be able to sue them for it. And they certainly don't face any criminal charges. So with the lack of deterrence, there's nothing to really hold them back. And what really adds insult to injury is if you're a defendant and your conviction was caused by prosecutorial misconduct, not only do you have to get the court to agree that misconduct happened, but once they agree with you, their next question is, was it harmless? Would you have been convicted anyway? And if the answer is yes, they would not give you the reversal. To me, that's a fallacy because, first of all, if it was harmless, why would they bother to engage in it? And secondly, once misconduct's happened, it alters the lens from which everything in that case flows. So in terms of addressing that deficiency, I think having the Commission on Prosecutor Conduct, so that independent oversight board, which would have subpoena power, they could complaints could be anonymous. So one of the reasons why the Bar Association and the Grievance Committee have been ineffective is that defense attorneys don't like to file complaints because they're worried about retaliation against themselves or against their future clients. The plea bargains that would otherwise be extended suddenly wouldn't be. So it addresses that. The complaints could be anonymous, and they would have the expertise also. I mean, things like the Bar Association, I mean, they're in Grievance Committee, they're really more geared to misconduct on the civil side, like commingling funds and things like that. They don't necessarily have the expertise dealing with misconduct. So the commission could address that. Another reform would be, removing immunity. So the argument for why prosecutorial immunity exists is that we want the prosecutor to be able to do their job without fear of intimidation, worrying about being sued. We want them prosecuting criminals, not defending lawsuits in court. And it could have a chilling effect. But my answer, my rebuttal to those objections would be that, police officers, forensic scientists, other law enforcement, they have no immunity. They're not prevented from doing their job. If you don't want to be sued, don't run over anybody's state or constitutional rights to stay within the bounds of what's proper. And lastly, I think that when there's been clear-cut intentional misconduct, such as withholding evidence of innocence, and that that results in a wrongful conviction, then I think that there should be criminal penalties because, in effect, the prosecutor has really kind of pulled off a legal kidnapping under color of law. So the same way, if a civilian commits a murder, not only would they face criminal charges, but the victim's family would have the option of suing as well for wrongful death. So in that same vein, I think that there should be not just the civil penalties we've talked about, but I think that there should be a criminalization. I think that there should be an incarcerative aspect to that.
Yes, well, I certainly agree. You don't have to convince me. So Jason would like to know more about how race intersects with false convictions.
Sure. So an African American is 7 times more likely to be wrongfully convicted of murder and 3.5 times more likely to be wrongfully convicted of sexual assault. We spoke a little bit about the death penalty before. So if the victim is a minority, then the defendant is less likely to receive a death sentence. Just like a defendant, if a defendant's a minority, then they're more likely to receive the death penalty. There's a further intersection in terms of sentencing. So minorities are often given much harsher prison sentences for the exact same charges, even with similar facts. So there's that. And New York recently passed a law called less is more, which would address the issue of technical parole violations. So really quickly, in terms of technical parole violations, while I was in prison, there were a lot of people who were paroled and then they were returned back to prison, not for another crime, but for a violation of parole. So often people would be sent back to prison for a year or for 2 years because their curfew is 8 o'clock and they got home at 8:10, or they failed to tell the parole officer about a change of address. So things like that. And so the less is more eliminates reincarceration for most of the violations. There would not be immediate incarceration if there is an alleged violation, but the person on parole would remain free pending the outcome of the court proceedings. And if there is reincarceration, it would be for 30 days, not for a year or two. But that crosses over into intersection of race and criminal justice, because African Americans are 12 times more likely to be returned to prison for technical violations, as opposed to
12 times more likely.
12 times more likely that their alleged technical parole violation will result in incarceration than as opposed to somebody of a different race. And I do want to mention, just for context, that that 6,300 people were reincarcerated for technical parole violations. So you can do the math, and so it's definitely a really tremendous impact. And when you get away from the stats a little bit, and the stats are important just to understand the context and frequency, but when you think about the practical implications of what we're talking about, so we're talking about fathers or brothers or uncles, so in the family unit, very important. I mean, often men are the breadwinners, or at least one of the two. If it's a two-parent household and both parents are working, still losing the income, losing the ability, to have the other parent present, the guidance, the tutoring, the discipline, the interaction. It's a family unit, called that for a reason. So when people are returned back to prison for a technical violation, I think it strikes a blow in a negative direction for that. And think about this too. It's I forgot the exact number, but I know it's more than $70,000 a year. Like, again, in New York, it'll vary state to state, but per year of incarceration. So instead of having somebody that is paying into the tax base, they're instead drawing tax money out. So many different reasons for this particular change.
Yeah, thank you. Thank you. So that's a good segue to talk a little bit about bail reform, because the cash bail system that we have also puts people in jail for, the technical reason that they can't afford to pay bail. And that is decimating communities as well for no good reason. There is someone who wants to know, this is a yes or no answer maybe, was a grand jury involved in your case?
Yes, a grand jury was involved in my case, and there was misconduct there. So one day before officially getting the DNA test result from the FBI lab, the prosecutor ran to the grand jury and got me indicted so that they didn't have to present that DNA test result to the grand jury.
Thank you.
But I'd like to just mention just other juror misconduct, not the grand jury, but just at my trial. Quickly, and this happens to people also. So the jury sent a note out to the judge asking that if they did not come up with a verdict, and they deliberated for 3 days, would they have to be sequestered over the Christmas holiday? And the judge told them yes. And sequestration means that would they have to remain in a hotel? They're not supposed to have the access to the news, television, and supposed to have interaction with their family, very limited. And I've learned in the years after I was exonerated. So one of the jurors reached out to my attorney and my civil rights lawyer and said that he saw that I had been exonerated and released, and he was happy about that because he never thought that I was guilty. And my lawyer asked the obvious question, which is, well, why did you vote that way then? And he said to me that, well, not to me, but to my lawyer, that it was 11-1 for conviction at that point, and that they were all pressuring him. And when the note was sent out, that really amped the pressure, and the answer that they would be sequestered came back in. That really amped the pressure up, and that none of them wanted to be sequestered over the holiday, and that he didn't either. And that was why he switched his vote.
Yeah, 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 yeah. The system, whew, the system is broken. So
Sheesh.
boy. So I do want to talk a little bit about bail reform, and we do have a
Right,
couple
right,
of
right.
questions in the chat, but no, that's okay. And I'm gonna let me just say that I know that New York State did pass a lot of stuff around bail reform, and then now there's a lot of pushback because that they're saying that now the that all it's doing is letting criminals go free and so forth and so on. What do you have to say about bail reform? What does good bail reform look like? What's going on with the current system, and what does it look like?
Sure. So, yeah, I have heard a lot of the fear mongering, and I've heard the pushback arguments, which you referenced. So, my pushback to the pushback arguments is that, look, when somebody remains incarcerated simply because they're not able to make bail, then they're in effect being punished for being poor. All right. So, the idea that if the idea that if that it's suddenly safe to release somebody if they can make bail, but if they can come up with the money, but not safe to release them if they can't. I mean, that simply doesn't make any sense anymore. And another thing is this: is a lot of people that are pushing back on that. They're saying, well, people are going free, they're committing crimes and going free. What they're not taking into account is that that person still hasn't been proven guilty. They still have a presumption of innocence. They haven't had their, they have not had their day in court yet. So that would be my answer. That would be my answer to that. Trying to assess future dangerousness. I mean, again, you're presuming that someone is guilty prior to them having their day in court. Ankle monitoring and house arrest are also options whereby somebody could be home pending the resolution of their case, but an additional level of security uh, for society. Let me also say, on a practical level, uh, fighting your case, going back and forth to court while you're free versus doing that while you're incarcerated, there's a tremendous difference. Many people plead guilty to crimes that they're not guilty of, just to simply stop going back and forth to court. I remember I went back and forth to court prior to when I was bailed out, and they wake you up around 5 o'clock in the morning so you can go. You stay in this overcrowded bullpen area, and they put you on this chain gang. Your legs are fastened together. It's fastened to the prisoner on next prisoner next to you. You're in handcuffs. They got way too many people in the holding cell, so you turn into a sweaty mess. Same thing, and you're in the back of the truck of the vans that are transporting you, and then you're in these holding areas in the court, like for hours and hours and hours until your case is called. And once it's called and it's done, you go back into that. You're there for the whole day. Every time there's a continuation, 30 days, 60 days, 90 days, that means you're going back to jail to stay there. And that type of
Meanwhile, if you had a job, you've lost it. Your family is suffering. You're in incredibly unhealthy conditions. You're not being taken care of, and you're psychologically and emotionally suffering because you cannot afford to pay bail. I want
and
to
you may lose
encourage
your housing
people,
too. You may lose
and
your housing.
absolutely, and you look exactly. So whatever you have is now gone because you're not working, you're not able to pay your bills, and you're not present, in the community, and that in itself has just devastating outcomes for everybody concerned. Folks, go ahead and start raising your hands. You can let's start Q&A from the community. Mr. Deskovic, someone asked about private prison lobbyists and their impact in the movement for change.
Sure. So Private prisons, I consider private prisons, i.e., prison for profit, to be unethical. It's unseemly. It's an unseemly way for somebody to make money own a prison. And so when things are being just run on a profit-driven bottom line, they're going to scrimp on services. Does anyone want to care to venture where they're going to make cuts at? Programs, medical services, whatever they can avoid to save money on. So I think it's unseemly. And another thing is that they do have a lobby, as the question implies, and they often lobby against laws that would result in less time incarcerated. So they often lobby against them. We saw that too in New York, which doesn't have private prisons, but the correction officer union, when there was movement to change the Rockefeller drug laws, which in brief, if a defendant was caught with a certain amount of drugs, a small amount, they would be eligible for like sentencing of 15, 20, 30 years. And when the movement was afoot to try to change those sentencing laws to bring those penalties back into proportionality so we could simply achieve fairness, the correction officers union fought against the changes. So they were able to make the connection that if they changed those laws, that would mean that less people would be going to prison for and when people were sent to prison, that they would be incarcerated for lesser time periods, and that people that already were sentenced under those laws, that some of them would be released, and that would ultimately translate into less beds, and that might even lead to closing some of the prisons, and that would translate into less correction officer jobs. So unseemly things happen when a profit motive, is tied, making money is tied, jobs are tied to incarceration. Very unseemly.
Yeah.
Yeah, it's more than seemly.
Okay.
No, definitely a lot more than that, but that's just what comes to my head initially.
So going into the Q&A, we have Adine, Leah, and then Gail.
Can you hear me all right?
Yes.
All right. Mr. Deskovitz, it's good to see you again. I saw you in Westchester County when you spoke at an outdoor rally on conditions of elderly prisoners several weeks ago. So it's wonderful to hear you again. My question is this. I'm looking at the root of the anger of the conservative white American that perpetuates this violence, this violent criminal justice system. And I look at it in comparison to the way white Europeans tend to run much more humane prison systems. I'm looking at the Scandinavian countries, Netherlands, even Germany, much more humane. How much of this vicious American attitude toward the criminal justice system is rooted in American slavery?
Yeah, definitely some portion of it is. It's hard to quantify it. I think that's a significant part of the answer. I don't think it's the total answer. Some of it is fear mongering and misinformation as well. That's put out there by often politicians who run on a tough on crime mindset. So we've seen some of that in terms of the pushback on bail reform. So I think that's definitely an aspect of it. And another thing is that the emphasis in those countries that you're referencing, the emphasis is on rehabilitation, the emphasis is on restorative justice, not a punitive model. So I think that our model being punitive is a big aspect of it, and then taken too far. I mean, just in terms of the number of people, credible people who can safely be returned to society through parole, or elderly people, 80, 85 years old, still in prison, or we have to get the very last day out of somebody who's terminally ill because their sentence is not up. I mean, it's not. Too much of it simply boils down to, it's not justice anymore. It's just revenge, and revenge is rule of mob, And that's not justice.
Thank you.
Leah?
Hi, Mr. Deskovitz. Thank you so much. I really appreciate your story, and it seems to be right up my alley right now. I've gotten involved in police reform since Cuomo started Executive Order 203 last year, and I read the new Jim Crow, and I've been advocating for ending qualified immunity, as well as the Clean Slate Act. How hopeful are you that Cuomo will pass your bill that you're advocating for into law? I mean, I see him, even though he did Executive Order 203, it seemed to fall flat, and he didn't really take any action to change anything. And he just appointed Madeline Singas to the DA of Nassau County, who's very pro-police. I know the police and the prosecutors can work hand in hand in wrongful convictions. So how hopeful are you that Cuomo is actually on our side? And should we vote him out?
Okay, so let me say this. I am hopeful that I'm optimistic that that Governor Cuomo will sign the Commission on Prosecutor Conduct into law. I base that on the idea that he signed it into law previously, and he did sign in the amendment that we made to that law also. By the time that, we were able, the coalition group, it could happen to you, but we sent a letter with organizations urging him to sign the bill previously. By the time we were done collecting signatures, we had amassed 125 organizations throughout the state, and we were able to help pass 5 different resolutions by municipal governments calling on the legislature to pass it. So my point is, we were able to demonstrate statewide clamor. Let's be clear. Governor Cuomo is not a criminal justice reform advocate. He's not. He is, however, very political, and he is, like most politicians, he is concerned with getting reelected. So I think that he's going to sign that bill and the majority of other justice reform bills that come his way, so long as we can demonstrate that a significant amount of people want these changes and that those people vote. And I think that to the extent we fail to do that, we can expect him to, not do that. And to the extent that we can do that, then I think that he will, that he'll sign. But as far as him getting on board early on in the process and helping to push it through and use the bully pulpit and use his clout, no, that's not going to happen. We have to do the work. And the same thing, not just him, but, even a lot of the other politicians. I mean, sadly, politicians of both political parties, they rarely do things because it's the right thing to do. It's only when getting votes and getting elected and getting reelected is tied to that. So you did mention the governor's order on police reform and how you got involved in that work. So I was appointed to I applied to and received commission to serve on the Peekskill Police Task Force Reform Group. Also pursuant to that order, I was assigned to the policy subcommittee. I was able to work with the sitting police chief of Peekskill, the county police officer, a retired cop, and we were able to get consensus over a bunch of policy changes, and ultimately a report from the task force group as a whole, including but not limited to that committee I served on, was sent to the Peekskill City Council, which voted to affirm that. So I do want to mention that the advocacy work, the justice reform issues, both wrongful conviction related and not, They're not anti-law enforcement. They're not anti-prosecutor. They're about justice and accuracy. That said, absolutely against any rogue police officers, absolutely against any rogue prosecutors. I explicitly reject the rhetoric of a few bad apples. No, it's not a few bad apples. If it was a few bad apples, we would not have all of the police brutality. We wouldn't have all the unjustifiable, deadly police force. We wouldn't have nearly 3,000 exonerations per the National Registry of Exonerations from 1989 forward. That said, I think that the professions are essential, and look, it's not like it's like any other profession. There's good people in it, and there's bad, but it's not a few like they say. So I have been able to make some outreach and work within some law enforcement. I mentioned working on that subcommittee. I was also on the transition team for Westchester County District Attorney Mimi Roca. We drafted memos for her conviction review unit that would proactively look for wrongful convictions. And for the last 7 years, twice a year, I've been brought in to speak at Bergen County Police Academy in New Jersey for the incoming police cadets. And my message there, after giving them an example of one case, one person, which was mine, I explain all the different ways it impacted on me in the society. And I explain, look, you're really the first line of defense. Okay, if you don't arrest the wrong person, then the train never pulls out of the station. I've been able to speak in front of some groups of prosecutors and district attorney offices. So, and similarly, I have spoken at rallies, and I want to say that while I'm on the side of people who have grievances against the justice system, and my life is based off of doing this type of advocacy work, tactics like violence and vandalism and destroying property are counterproductive. It really hurts the movement because now the conversation is not about the underlying issues anymore. It's about those things. So it is a distraction. So I have spoken against that, and just try to stand in the middle and unite, and also be true. Last point I'll make, and I want to get more questions in, but your statement and question really was packed with a lot of great stuff and gives me the perfect segue to share more. So I'll mention one more thing, and I do thank you for your question. You did mention qualified immunity. So qualified immunity, what that means is that even if the police have violated your state or constitutional rights, if there has not been a previous lawsuit where law enforcement or municipalities have been held to account for it, then the lawsuit would be dismissed. The legal theory of that is that law enforcement and municipalities, that they haven't been warned that conduct is punishable, right? So that's a general principle. You have to be warned before you can be punished. So that's been the theory of that, but of what qualified immunity is. It's a very devastating doctrine, because just because nobody has committed misconduct before and been held to account doesn't mean that you should be able to get away with it now. The state constitution says what it does. The U.S. Constitution, does what it does. And if you violate that, you should be held accountable civilly. And so I am glad that the qualified immunity has been rolled back. And one key principle of viewing justice reform changes that I've mentioned throughout this conversation, and that I mention in general, is the idea that there should not be a two-tiered justice system. So if a civilian, Leah, if you break the law, I hate to tell you, they're coming for you, okay? And you're going to be held to account. And if I break the law, I can expect the same thing. So why should law enforcement or prosecutors have any kind of technicality to work for them, so that if they break the law, they can't be held to account, whether that's criminally, whether that's civilly? And as important as the police reform is, and it is extremely important. We can't forget the prosecutor. It's the prosecutor who allows police officers who commit the acts of brutality of deadly police force. Suddenly, they can't get an indictment anymore. Suddenly, they can't get a conviction anymore. When police officers engage in brutality, to cover themselves, they often arrest the victim of that brutality, and he assaulted us. We were defending ourselves. And sometimes these things are caught on camera, but it's the prosecutor that carries out these charges and prosecutes them in court, rather than dismissing the charges and, no, we're going after you because tape is clear, you did the brutality. It's the prosecutors that utilize false confessions obtained under coercion. They're the ones using that evidence in the courtroom to get a conviction. They're the ones, if evidence is seized in violation of a constitutional right, they did an unreasonable search and seizure. They had no right to search your car, but they did it anyway in violation of your rights. It's the prosecutors that are using that evidence rather than saying, no, this was unlawfully obtained and I'm not proceeding ahead with this case unless you have some other evidence that was not obtained illegally. So while we do have to continue on with police reform, we can't forget about the prosecutors, because while we passed the commission bill, we got it through the legislature, waiting for the governor to sign it now. But while we got that through, that's only in New York. We still have all the rest. We still have all rest of countrywide to go, as well as federal government.
Thank you. We have Gail, Tyrone, and then Kathy.
Hi, thank you very much, Mr. Deskovitz, for all the work that you're doing, and everybody else here who's working so hard on prison reform. I just want to read what I put in the chat a while back, because I can't remember it with my memory right now. In regards to wrongful convictions, just wrongful convictions, I'm not looking at all the issues of prisons. What will always be a problem, and do you see, in avoiding it, even if you get all the changes that you work so hard for? After all, no system is perfect. We're only human. What mistakes do you foresee as inevitable? And then the next question I have is there a model a prison system somewhere in the world that you support? Thank you.
Yeah, so I'll deal with the second question first. Norway. I really like the prison system in Norway. There was an expert when I was in law school. Somebody came from Norway, and they spoke about the prison system there. And it was, much more. Much more humane system. And as I mentioned, it wasn't like a purely punitive model. But another person in their question also mentioned other countries. So really, Europe as a whole is ahead of the U.S. with respect to the prison system. In terms of inevitability, factors which would lead to wrongful conviction. So even if all the changes we've talked about here took place, what would be some factors that would still make wrongful conviction inevitable, keeping in mind that we all are human, and even under the best of circumstances, sometimes we err, and too many times in these cases we're not under the best of circumstances, we're not acting in good faith. But so a few things, certainly tunnel vision. So tunnel vision means when somebody, we'll talk about a police officer, we'll talk about a prosecutor. Tunnel vision refers to when a conclusion is formed, then the tendency to only latch on to, only pay attention to evidence that supports that conclusion, while ignoring evidence that does not, or coming up with obscure explanations for the evidence which almost defy belief. So an example of that would be when I was arrested, before I went to trial, the DNA test result came in, and rather than dismissing the case against me, they instead continued to prosecute. they came up with this theory that without any evidence, they came up with this theory saying, well, the victim was promiscuous and she must have slept with somebody else the same day that you raped and murdered her. So first of all, if that really was true, then that would mean that there would be DNA of two people there then, right? Not one. Secondly, they never came up with anybody to testify that she was promiscuous. They went further and mentioned somebody by name that they claimed that she had slept with. They never had DNA tests performed to prove it. They never called him as a witness. Police went back out into the field, interviewed 17 witnesses who knew the victim in one capacity or the other, and all of them told the police she didn't have a boyfriend, there was no consensual sex. Cops did not record those interviews, and so therefore they didn't turn it over. But you see how that's my point in terms of tunnel vision. And we see that also disturbingly when evidence of innocence is discovered after somebody's been convicted. We see the prosecutors still want to hold on to convictions, or they still come up with different theories. Could be something different rather than being led by whichever direction the evidence takes you, just holding on to that, holding on to that. So I would say that's a really big factor. And maybe another thing that could be fixed with legislation, but really is not addressed, is just the inadequate funding for public defenders. There's a big disparity between the funding that public defenders receive as opposed to district attorney offices. And the district attorney has almost they have access to investigators and experts, and the public defender limited experts, limited investigators. Often they have to resort to asking the court to allocate discretionary funding, and those requests are often denied because the judges are trying to keep the cost of trials down. It's not unusual for one public defender to simultaneously represent 100 people at the same time. So if you've been to college, imagine if you had to carry 10 or 20 courses at once. Imagine now we're talking really 100 cases where people's lives are on the line, not merely grades. So those. But maybe the other thing will be morality. I mean, too many times the wrongful conviction cases, they're prosecuted by ethics. Legal ethics are supposed to be what's referred to as a minister of justice. That means you convict the guilty through legal ways using lawfully obtained evidence through a trial that respects everybody's state and constitutional rights, and dismissing cases against innocent people. That's what it means to be a minister of justice. You're not simply there as a prosecutor to win. And too many times it simply becomes about winning. It does become another gold star, as somebody mentioned in the chat box. And what would the motivations be? Well, there's a reward, there's a high-fiving, there's a celebration, like it's a celebrity event if a conviction is won. There's possibilities of being promoted, and promotions bring prestige. They bring raises, maybe more money. Maybe some of the prosecutors aspire to be the district attorney one day. Maybe the district attorney is concerned with getting reelected, or maybe they're looking to use that office as a stepping stone to higher office. And so winning becomes the only thing. So the morality is an aspect of all of this that I don't really think is fixable by structural changes that we're talking about. So I think even when we do pass all of the structural changes, I think that we'll wind up with a more just and accurate system, but certainly not one that would be foolproof.
Thank you. We have Tyrone, Kathy, and then Lou.
Good morning, Counselor.
Good morning.
Thank you so much for being on this call. I have a lot of respect for you for going through all this crap you went through and still come out on the other end really wanting to help people. And to me, that says a lot about your character. I want to pick up on where Sister Adine was on her root comment. And I made a note in the And thank you, Kathy, for responding to that. But I slipped a little note in saying that, and you used the term, Adine, white conservatives. And I was making a point that white conservatives or white liberals are not immune to fear. And what I mean by that is that, to me, fear, lack of security, is at the very core of our criminal justice system. The more people are afraid of what's going to happen to them, the more they have no problem with locking someone up and hoping they stay there. And so that makes it a really, excuse the pun, black and white situation. There's no gray area, in situations like that. So I completely appreciate what you're saying, but I wanted to make that point. And frankly, not only white conservatives and white liberals, most people, because we are programmed to the law and order world. I remember in the 80s, law and order, that was a big deal. I hadn't even realized that here. Law and order meant that, a disproportionate number of black and brown people are in jail. To me, does that suggest that black and brown people are inherently criminal? Of course not. But there's this belief that gets carried on. And the tragedy is that it's been carried on since the prison system was created. So that's my 2 cents.
Sure. So I'll just quickly make a comment. I think, I think that there's, tying back to a point that I made, I feel like there's some percentage in the professions that are really not committed to justice. I mean, Clarence Thomas is black. I think he's probably the worst justice on the court. So it has to have, it's beyond it. I guess what I'm saying is that we shouldn't be fooled by people based on their, but just strictly based on their skin color. I mean, Alberto Gonzalez, who reached very, very high in the U.S. Attorney General's office when Bush was the president, he signed off on torture memos. So I think that when people run for office or have nominations, it can't simply, the inquiry cannot and should not agree. Our decision as voters and as other elected officials, should not begin, middle, and end with, well, what ethnicity or what color they are, because I don't feel any better when an injustice is upheld by Justice Thomas, for example, just because of the fact that he's black. That doesn't give me any solace. I want justice no matter what. And speaking of that, it's really important, I think, that we have people that, we have to get behind people who are running for office of either political party, all right? Because justice reform is not owned exclusively by the Dems. So I think it's important that we vote people in of either political party when they're running on a justice reform plank and they have some sort of body of work that existed prior to their running for that office. And people that are standing in the way of justice reform policies, we got to vote them out of office, and we got to vote other people in. When you think about a district attorney, as someone I saw briefly in the chat box, D.A. Krasner, for example, there are a little bit more than 20 exonerations that have happened through their conviction review unit. That would have never happened if people didn't vote him in office. In New York, Ken Thompson, when he brought down a 16-year incumbent, Brooklyn DA Charles Hines, who had been there, like I said, for 16 years. And, Ken was an underdog, but he ran on a wrongful conviction prevention plank and a justice reform prevention plank. And 23 people were exonerated in 2.5 years that would have never, ever seen the light of day. So my point is, it's important who we vote into office. And when we get the right people into office, the results really can be breathtaking.
Thank you. We have Kathy.
Yeah, thanks. And thank you for that last comment, because I was wondering, what in the world can we do? And about the issue of fear, I think a bigger problem has been our apathy and our just not understanding the terrible things that are happening in prisons and why they're happening in prisons. And I'm really shocked and appalled by the withholding of evidence of innocence. That is just illegal. And people who do, prosecutors who do that should go to jail. Um, I just did not. I was just not aware that there was so much lack of ethical integrity in in the area of prosecution. So that's really horrified me. But thank you for posting your information about sending money to your projects, because I'll do that. And certainly bringing up the issue of criminal justice reform as people are running for election. That's also something that I can do, is just make myself super aware of where they stand on criminal justice reform. Do you have any other suggestions for what even, just a well-meaning white liberal, can do, or anybody can do to change the situation?
Sure, absolutely. So I think a number of things. So when there's events or calls like this, or in person, just simply attending, when there's petitions that are circulated, signing. In terms of jury duty, don't you dare get out of jury duty. That's a really big problem. And what happens is when people get out of it, the only people left there are going to be people that are not going to scrutinize the prosecutor's case. Prosecutor has supposed to prove guilt beyond a reasonable doubt. So that means if they haven't done that, then even if you suspect the defendant committed the crime, you're supposed to vote not guilty. But I think that, people don't do that, and people that are not scrutinizing, that's really what's left in the jury pool. I do want to mention, as you can see, up will be the upper right-hand corner in the background. I do want to quickly mention, there is the Amazon Smile program. So if you register the Jeffrey Deskovic Foundation for Justice, on that, the Amazon will donate a small percentage of your purchase without it increasing the cost on the consumer. We do have the Patreon campaign. When I look at politics and statewide races or presidential races, we see that double-digit millions, sometimes triple-digit millions, are raised on behalf of political candidates, often in what's referred to as small dollar donations. So, why can't we do something like that for justice reform? So the foundation, for example, we do have a page on the Patreon website. So dream with me for a minute. What if 25,000 people were willing to, free innocent people and prevent wrongful conviction? They were willing to sacrifice $3 or $5 a month on a recurring basis through that. That would give us increased capacity. We could hire additional lawyers, paralegals, investigators, other essential personnel, so that we could work on more wrongful conviction cases. We could push policy more than just in New York, California, and Pennsylvania. I think a lot of times, speaking to apathy, first of all, I think people think, well, being a donor that's a rich person's game. It's not. No, but people, even of modest means, you could, every little bit does help. And I'll share quickly, and I'll move on, that, I work about 50 or 60 hours a week, and, I don't get paid anything. I just do it from the heart. And my point is that 100% of the funds that are raised will go towards freeing innocent people and the policy changes. But other things that people can do also, misconception is that you have to be wealthy or politically connected or part of some corporation in order to contact your elected officials, your senators, and your assembly people. But no, anybody can contact them and express support for criminal justice reform. That really does make a big deal. It does make a big impact. Some places you can volunteer. With new media, we see, Blog Talk, the advent of Blog Talk Radio and podcasts and even written blogs. So, the platforms for us to express our freedom of speech are increased. So maybe that's something within somebody's purview. Documentary, docuseries, learning more about the issues and sharing that. Maybe as things clear up with the pandemic, maybe there's a movie night or documentary night where information is shared through viewing. So all these different ways, and many more. This is just what comes to my mind immediately as we're talking. But if we have to have everybody doing something. on it, and it'll all help. This is much more than what I can address on my own. I'm playing my role, but we need all hands on deck doing everything that is within their means.
Yes, all hands on deck. Thank you. Lou? Lou, is this your first time here?
Yes, it is.
Welcome.
Thank you. It's nice to be with everybody. So this is sort of going back to an earlier question that you got asked, and it continues to perplex me because inherently, prosecutors not only need convictions, but they make so much more money than the defenders, like almost all of the time. It seems to me that you might not be able to get people to morally sign on because of that reason. And so I'm wondering what avenues could be taken to help equalize that field so that in the very beginning, you're getting more fair juries, you're getting more. I also think juries should be compensated a little better if they're going to come to be a jury. And the disparity between a prosecutor and a defense is just ridiculous. It's ridiculous. And what can we do about that?
Sure. So, I mean, as I mentioned earlier in a different answer, I do think that there should be parity between the district attorney's office and the public defender's office in terms of manpower and budget. I do agree with you that we need to have equal pay for both sides so that the best talent doesn't go to one side or into private practice. And we really can't afford to send a message that one person's, that the prosecutor's job is more important than the public defender's, because in truth, they're both equally essential in terms of getting just outcomes. I do like your idea of better compensation for jurors, and that's a big incentive why people of modest means often do seek to get out of jury duty. Is they can't afford to miss the work, and what they are going to get from serving on a jury is much less than what they're going to get from their job. So I do think that that is a credible idea. I do advocate for a statewide system of public defenders so that there could be oversight and quality control as opposed to just county by county. Because even though these economic disparities we've talked about exist in cities, they become even more pronounced when we get to rural parts of each state.
Indeed.
Thank you, Lou.
Thank you.
We have John, and then we have Jeff, and maybe Jeff would be our last question. Well, I have one after Jeff.
Yes. Thank you, Jeffrey. This is a fantastic discussion, and I look forward to working with your organization. But I wanted to speak to something that Tyrone said and get your thoughts on it, and that is with interest to racial prosecute or more racial focus on investigations and prosecutions. In New York, for a long time, they did stop and frisk where people were told to empty their pockets in public. And I know of several cases, there are probably hundreds, there where a guy had less than a quarter ounce, let's say, of marijuana in his pocket, which is not illegal, not a criminal offense under state law, but a fine, a violation. But they had it in $10 bags, which maybe meant 5 or 6 bags, and they were immediately convicted for public display of for sale substance. The assumption was made that simply because he had this small amount in little baggies or little bags, they were intent to sell. There were hundreds of convictions on this, and that is an abuse of prosecutorial and police tactics. From the beginning, any prosecutor would say, well, this is not a violation. This is simply a violation because of the quantity, and the intent to sell was not an established under the law. And I would just like to know what, Jeffrey, you think of prosecutions of this nature on a large scale for, a small instance of justice, and I'd like to know what your thoughts are on it. And it's an abuse, and how do we address that?
Sure. So I do think that it is a waste of resources. I'm familiar with what you're talking about. And I mean, the whole thing was disingenuous really from the beginning because there was no public display. The public display, one that happened voluntarily, the public display happened because law enforcement was forcing people to take things out of the pocket. So I am glad that ultimately, well, that and stop and frisk are, thing of the past. But aside from that aspect to it, there definitely was another racial intersection with the justice system. A lot of people that were subjected to stop and frisk were minorities, and that kind of is emblematic of a related issue that I'll tie in with respect to selective enforcement. It seems to be, drug usage is something that, there seems to be a selective enforcement in drug usage in minority community and not in the non-minority community. So I think that uneven application of the law, continues to remain an issue. There is a bill that did not get passed in the legislature, but I do want to make mention of it. This would be in New York. Bill was called the Challenging Wrongful Convictions Act, and it was introduced by Assemblyman Dan Court. And what that would do is, and this ties into other points that were made in the question. So right now, the way that the law is, if a defendant learns of evidence of innocence after they've pled guilty, right? Again, keeping in mind that there's evidence withholding and that innocent people do plead guilty. The way the law is now, a defendant would be prevented from raising an actual innocence argument if they've previously pled guilty. So that law would address that. Currently, in a post-conviction proceeding, which is when somebody is bringing new evidence to the court to be considered, there is no right to counsel. There is no right to an attorney in that proceeding, and so that bill would allow that. And lastly, it would allow anyone who's been convicted of a crime that has then later not been a crime to challenge the conviction and remove that from their record. I mean, there was an issue in New York, for example, gravity knives, and people were using gravity knives and, for work purposes. And if the law enforcement can flick the knife out, if it opens, then, it doesn't, and they have unlimited times to do that. And if it opens just once, then that could be the basis of a charge. So that, that law, that particular law is a reference of something that's, gravity knives are not illegal anymore, but people still have convictions and they suffer the secondary impact of those convictions, whether it's serving on juries or, difficulties in getting employment because there's a record, whether we're talking about voting. And I'm going to step away from my organization for half a second here and just make a statement on my own, not endorsed by producers of today's program. I do want to mention, we talked about the impact of having the right people in office. I do want to mention that Dan Court is running for Manhattan District Attorney. I have a long record of working with him. He's spoken at press conferences with me on criminal justice reform measures and other wrongful conviction prevention issues. He's voted before for the Commission on Prosecutor Conduct, discovery reform. He referenced my case and other wrongful conviction cases and explaining his vote, why he supports the oversight for the prosecutors. So right now we don't have a real conviction review unit in Manhattan. Dan is on record as saying that he knows that there are wrongful conviction cases that are happened in Manhattan that remain intact due to lack of having a conviction review unit. So please go out and vote on the 22nd of June, period. And for whatever races in your jurisdiction. And if you're a Manhattan resident, I would urge you to consider voting for Dan Court for assemblyman, who's an assemblyman who's got a great body of work as that, who's running for Manhattan DA.
Thank you. And then we have Jeff.
Yeah, that kind of leads into my question, Jeff. Have you ever in all your work as a lawyer encountered a prosecutor whose behavior you respected being fair and looking for justice and being honorable.
Yes, yeah, yeah. So there've been a couple of instances. So I have a lot of respect for Bryce Benjet, who heads the conviction review unit in Queens. There, you know, there have been in his approximately a year and a half tenure there, eight people have been freed through the conviction review unit that he heads. And Bryce has a solid body of work that he did. Some of his job prior to that office was working as an attorney at the Innocence Project. So he's helped to exonerate people in that capacity. And then he made the jump to the DA's office to help continue to do that. And I will say that the one dealing I've done with Anastasia Heger, who heads the conviction review unit in the Westchester DA's office. Her and of course her boss, Mimi Roca, the Westchester DA, who I supported as an individual. I worked for her election, and now that they're in office, I was co-counsel on a case, the Carolyn Warmus case that made the news, with several other lawyers, and we approached the DA's office and we urged them to allow our client to get further, well, not even further, but to get DNA testing in the first place. And they agreed to give us the testing. So based on those things, I do respect those three prosecutors. And yeah, that's, there's another ADA, Jake Barnett from the Rockland DA's office. So another case where, foundation is involved in working to exonerate someone who's wrongfully convicted, and the office allowed the client to consented to the DNA testing rather than making us go to court and litigate over it. So those are instances where prosecutors that I do respect that I've met.
Thank you.
All righty. Thank you. Thank you, everyone, for your questions. Good. It's what? Right on time. Lane?
Thank you, everyone. Thank you, Mr. Dekovic. You have absolutely been a gem. And I hope someday I get to actually meet you in person so I can actually shake your hand. I want to encourage everyone to support you. And I do have the foundation. We do have the Patreon. Someone asked how to actually connect with you. Do you have a way for people to follow you, sir, or just would you prefer them to the Patreon account and that's it? I'd like to put something in the chat.
Yeah, of course. No, I have a way for them to follow me. So there is, so people want to contact me. There is our website. So www.deskovic.org. There is a web form that people can email me there. I am on social media. So I'm on Instagram, LinkedIn, and Facebook. You can follow me. I follow people back. People can message me through those. I am at my friend limit on the Facebook account. So I have a public figure page that I also have, which has no limits. And whatever I post on my personal page, I copy it over to the public figure page. So if you want to keep up with the advocacy work that I do, upcoming speaking events that I have, or interviews or articles I've written, media coverage, etc., as well as just I post things also about just wrongful conviction in general and justice reform in general, even if it doesn't pertain to me. So if you'd like to keep up with the issues and learn, keep up with me, etc., all those ways are ways that you can do that. I do want to quickly mention that, as you mentioned at the intro, I do own the Recharge Beyond the Bars reentry game. And what that is that it's a tool that facilitates formerly incarcerated people along with their family and friends reconnecting. So I remember when I was released, and again, I did 16 years. I found it very hard to communicate with my family and friends when I knew that nothing in their background would have enabled them to really know what it's like to go through a trial or incarceration or the difficulty in reintegrating. My brother, who's 3.5 years younger than me, he said to me once, he said, "I don't know what to say. I don't know what not to say. I don't know what to ask. I don't know what not to ask." So Recharge steps in the middle and removes that awkwardness through posing icebreaker questions. I'd like to quickly give the website for that. It's www.rechargethegame.com. So you can check out the check that out as well. So
Great.
listen, thank you
Thank
very
you.
much for having me on today. I really enjoyed myself. I enjoyed the format. I got to share knowledge. I really liked the level of interaction, and this was more of a conversation rather than just standard questions or even just really long monologues. So it was a kind of a breath of fresh air for me today, as compared to what other hosts on other programs have requested me to do. So I appreciate the variety in today's program.
Wow. Well, thank you so much. That's great. That's wonderful. I'm glad you enjoyed yourself. You're welcome anytime.
Anytime.
Folks, please join us next week. We'll have another great conversation for you. And don't forget that June 19th, is state official holiday in some states across the nation. And do your research to find out the significance of Juneteenth. It is extraordinarily important for African Americans. Eugene, last words.
Again, Jeffrey Deskovich, thank you very much for your time. Thank you everyone who continues to show up, and for those who were here today for the first time. Blue, thank you for having the courage to ask your question with your first time here. And from Lane and myself, we really, really do appreciate all of you here at Race Talk Revolution, because it is important for us, for you to know that your voice matters.
Amen. And so it does. Have a great week, everybody. See you soon.